If you're thinking about reporting sexual assault, I want to talk about what to expect in a criminal trial in Canada. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people and people who have experienced sexual assault get the compensation that they deserve for their injuries in the civil justice system. If you've been sexually assaulted and you're thinking about reporting it to the police, you probably have a lot of questions and maybe some fears. You might be wondering about what happens next, and that's completely normal. There's a lot of information out there, and sometimes it's confusing or even sometimes misleading. Some people say that the justice system doesn't care about survivors. Others say that reporting is pointless or that you'll be attacked in court. While the process can be difficult, it's important to know what's true and what's not and what rights you have. So today I'm going to give a little bit of information to help you understand what happens during a sexual assault case in Canada's criminal courts. And by way of disclaimer, I'm not a criminal lawyer. I am a civil lawyer, but this is my understanding of what happens in the criminal courts in a sexual assault case. So first, you should know the criminal justice system is not perfect, and neither is the civil justice system. But criminal trials are meant to figure out what happened and decide if the accused, so the person charged, is guilty. Everyone involved is human: judges, police, lawyers, witnesses. So the system isn't perfect because humans aren't perfect. Mistakes do happen. Sometimes guilty people are found not guilty, and sometimes innocent people are wrongly convicted. The law tries to be fair to both the person who reports the crime, the complainant, and to the person who is accused. The accused is considered innocent unless the evidence proves that they are guilty beyond a reasonable doubt, and this is a really high bar. This means that the process is serious, detailed, and sometimes stressful for everyone involved. The next thing to know is some people don't tell the truth, and that's why trials exist. It's hard to imagine, but sometimes people lie, so both about being assaulted and about not committing an assault. And that's why courts don't automatically believe or disbelieve anyone. A criminal trial is designed to hear both sides, to test the evidence, and to try to find the truth. If you're telling the truth, the court wants to hear you, but you will be asked questions, and they will be hard and uncomfortable questions so that the judge and jury can fully understand your story. You should be aware that there are rules about what questions can be asked. Many survivors worry that they'll be blamed or shamed in court, but Canadian law does have strict rules about what defense lawyers can ask during a sexual assault trial. There are some important precautions, so you cannot be asked about your sexual history except in rare cases. Defense lawyers are not allowed to ask about your past sexual experiences unless the judge agrees that it is highly relevant. Just because someone has had sex in the past doesn't mean that they agreed to sex this time in this situation. That's the law, and the court respects that. The next thing to know is you can't be judged based on how you dress, party, or how you live your life. The law doesn't allow questions that are meant to make you look less believable just because of how you dress, drink, or post online. The next thing to know is that your therapy and medical records are very private. If you've talked to a counselor or doctor, those records are not automatically shared with the court. The defense must get special permission, and the judge will review the request carefully. You can also have your own lawyer who will fight for your privacy. And I do have another video getting into this about O'Connor applications. You can see that one, it's linked below, and it gets into more detail about these third-party records and when they're producible and what you can do to prevent that. You might be wondering what happens in a sexual assault trial. If the Crown, so the prosecutor, decides to lay charges and go to trial, here's a general outline of what happens. First of all, charges are laid, so the police and Crown decide if there's enough evidence to charge someone. Secondly, you will give evidence, so you may need to testify in court, and answer questions from both lawyers. Third, the accused may testify, so the person charged may choose to speak, or they do have the option to stay silent. Fourth, the judge or jury decides. They decide if the accused is guilty based on all of the evidence. And then the fifth step is sentencing, and this only applies if the accused is found guilty. If the accused is found guilty, the judge will decide on a punishment, including sometimes jail time or sometimes being placed on a sex offender registry. Something to understand is that going to trial can be hard. Testifying in court is not easy. It can bring up painful memories and cause stress, fear, or anxiety. You'll likely have to go over what happened to you in detail, and the defense lawyer will challenge you on parts of your story. This can feel upsetting, but it is part of the legal process. And you do have support options. So victim services can help you to prepare for court. You may have someone like a support person with you while you testify. In some cases, you can testify from another room by video. You may qualify for a court-appointed lawyer to protect your privacy in certain situations. Some important truths to keep in mind. Most defense lawyers do not try to humiliate or bully survivors, and judges won't allow it. So it's good to keep aware of that when you are thinking about reporting. The next thing to know is that your credibility matters, but so does fairness to both sides. The next thing to know is just because a case is hard doesn't mean it's not worth pursuing. And even if the accused is found not guilty, it doesn't mean that the court didn't believe you. It just means that there wasn't enough evidence to meet the very high legal standards. So what I was mentioning before, that the Crown has to prove the case beyond a reasonable doubt. So it is a very high standard. So being informed is being empowered. The more you know about the process, the more prepared you'll be. Many survivors don't want special treatment. They want to be taken seriously, treated with respect, and have a fair chance to tell their story. If you're considering going to the police, you should know that you do have rights, you have protections, and you can access support. Overall, criminal trials for sexual assault are tough. They are emotional, slow, and sometimes frustrating. But for many survivors, reporting and going through the process, whether you win or lose, can be part of reclaiming your voice and finding closure. You don't have to decide right away, and you can speak with a lawyer, a victim services worker, or a support person to understand your options and make the choice that feels right for you. At Gerry Law, we are here to present an alternative option or an option that you can go through in conjunction with a civil lawsuit. So this can be done before the criminal process, in conjunction with the criminal process, or usually it's done after the criminal process. I can be reached at the contact information below to discuss your specific case and to go through your rights.